can I work without permission in the United States? Even or can I have done that? Is it going to be it's a long question, of course, but some people ask it in this way, is it okay that I have worked without work permit before, but now I'm, going about to start this case, or I filed this case for adjustment of status to my spouse, whatnot? Short answer, yes, it's okay. It's waived. In fact, technically, it's not a ground of inadmissibility. However, on my program here, I can share on YouTube and Facebook. I'm going to share with you. So on y'all on the other platforms, what I'm sharing is a page on the USCIS policy manual. I love to share the source, so that's why I'm just sharing it out loud. So in case you can't see it, this is what we call inapplicability of bars. Okay, so even though it's not a ground of inadmissibility, so here's a section up here, Chapter 8 of the USCIS policy manual. We always rely on this. You got to know the legal source. So I know a lot of lawyers don't really share this, even though our consultation is 15 minutes. But hey, we speed through. We know what to do. We know the action plan. We share it with you. Don't be shy to follow up with us and ask questions. It's really important you guys get the pinpointed information, but also know where the information's coming from. Especially the past, these past years with pandemic, y'all need to know the source, right? It's very important. So anyway, it says basically a list of bars from restrictions from getting adjustment. So here's a list of situations where those bars don't matter. They're waived, these scenarios. So for example, if you're filing through a spouse, or you're a U.S. citizen adult child, you're sponsoring your parent, or you're a parent, you're sponsoring a child under 21, then you can do this, and they're unmarried, of course. So even though you may have worked without a work permit, without the actual card, it's okay. They don't call your employer. They don't do any of that. They don't waste time with that, okay? Now, again, this is for what we call immediate relative. This is not for family preference. So if you have a petition filed by your brother or sister or your parent and you're over 21, whether you're married or not, that doesn't count. That's family preference. So that's why I'm trying to be extra clear on this information so you don't rely on this information incorrectly, okay? So another thing that's pretty critical, key difference here, is that it waives unlawful presence, okay? So if you have not maintained your status, there's similar legal concept, but slightly different, okay? So if you, now if you're here on a student visa or any other non-immigrant visa, like a e-visa, and then you're applying through family-based or employment-based residency, that's okay. You can get your green card here in the United States. You don't have to leave, right? So, but if you fail to maintain status and you're a family preference relationship or you're employment based, you have to maintain your status. You cannot. Now, keep in mind, for employment based, this goes even deep into the legal stuff, legal knowledge here. There's a law called Immigration Nationality Act of 245K that does waive up to 180 days of unlawful presence for employment-based cases. But for family-based and your family preference relationship, that doesn't apply. So I know a lot of information. All right, so that's basically the bulk of information I want to share for the topic of the day. I think that's it, folks. We appreciate it. All right, don't be shy. Give us a call, 832-838-9797.